I am Peter Taylor, and this podcast is concerned with how to settle commercial disputes without going to court. Mediation can hold the key. So what is mediation and how does it apply to commercial disputes? Mediation is a forum for settlement of disputes in which an entirely independent, specially trained third party meets the parties who are in dispute to help them negotiate a settlement of their dispute. Other common forums for resolving disputes include court proceedings, arbitrations, adjudications of construction disputes, and settlement meetings. According to statistics, disputes which are the subject of mediation have a very strong chance of settlement. The role of the mediator is most commonly as a facilitator of the settlement negotiations. He or she may test and probe the parties on their arguments, but without seeking to evaluate the strengths and weaknesses of the respective arguments. Mediation is often used in commercial disputes as an alternative to expensive court proceedings. It is particularly useful when the parties wish to preserve a relationship which court proceedings might irretrievably damage. By way of example, you may wish to preserve a relationship with your existing customer or with a supplier with whom you have a dispute. Solutions which the commercial parties might agree in a mediation can also be much wider than the limited outcomes which a court could order. Courts will generally look backwards and order damages or financial recompense for a breach of duty or breach of contract which has occurred in the past. Mediation, one can look forward to a solution that would work for both parties and preserve a working relationship if that is desirable, or find another solution or range of solutions which work for the parties involved in the dispute. Mediation is undoubtedly quicker and cheaper than other forums for settlement of disputes. Even if a settlement is not reached during the course of a mediation, it frequently has the effect of narrowing the issues in dispute, or the parties getting a better understanding of the other party's position and the merits of each side's arguments. In doing so, whilst a settlement may not be agreed at the mediation, it brings the parties closer together. One often sees a settlement agreed in the following days or weeks. Are there any disadvantages to mediation? In practice, there are few adverse consequences of mediation. If a mediation is unsuccessful, then the parties will have borne the cost of the exercise and may well feel it was fruitless. However, most mediations are successful in achieving a settlement, so the benefits to be gained will generally be considered to vastly outweigh the costs to be incurred. Seldom is there a case in which a lawyer would say it is a slam dunk winner. It may be that a case has a strong chance of success at court. One must bear in mind that by the time one has gone through the court process to get to a favourable outcome, the opponent's financial position might have changed, possibly as a result of the legal costs incurred, and the ability to pay any judgment significantly reduced. So now let's look at the procedure in mediation. The parties to a dispute will seek to identify potential neutral mediators and agree one to be approached. Thereafter, agreeing a date and venue for the mediation which is convenient to all parties, bearing in mind the mediator will also have diary commitments, is the next step. The mediator will provide a mediation agreement confirming the name of the parties, the date of the mediation, the costs of the mediation, and the nature of the dispute to be mediated. The mediation agreement will set out the basic principles and the rules of the mediation. During the days leading up to the day agreed for the mediation, the parties will submit to the mediator an agreed bundle of documents which will provide the background to the dispute and may be helpful to have available during the mediation. The parties may also give the mediator information and documents privately which they do not want to disclose at that stage to the other party, but of which they wish the mediator to be aware. The parties in the dispute will exchange a summary document setting out their own views of the dispute and what solution they are seeking. On the day of the mediator will introduce him or herself to each party and reinforce the confidential nature of the mediation. The mediator may often start with a meeting of all parties and invite each to deliver a statement. That is often an opportunity for each party to express exactly how they feel, and in doing so enable the parties to look forward to a settlement rather than spend too long dwelling on the past. During the day, the mediator will meet each of the parties privately and discuss the dispute, aspects of it, challenge stances being taken, and seek proposals for settlement to put to the other party or parties. It is important to bear in mind that the messages that are communicated to the mediator in those private meetings remain confidential with the mediator. Information or proposals will not be passed to the other party by the mediator unless he or she has the express permission of the party with whom the mediator has been having those private discussions. Invariably, there is an element of shuttle diplomacy involved, but eventually the outcome that is sought is a terms of settlement which both or all parties can agree. If the parties agree terms of settlement, then the parties and their lawyers will draft a settlement agreement prior to the parties agreeing and signing it. At that stage, and only at that stage, does the settlement become binding on each party. The mediation is akin to choosing a new car in a garage. You are not committed to it until you have found the one you like, or seen the settlement terms with which you can agree, and signed on the dotted line. The parties are not bound by anything in the mediation unless and until they agree to a settlement and sign a settlement agreement. What does the outcome of a successful mediation feel like? Parties to a mediation often express a sense of relief that a dispute is over. Some have shared a bottle of champagne that they have been able to settle their differences, a concept which might have been unimaginable at the start of the day. An experienced mediator would describe a successful outcome as the parties finding a solution with which they can each live, but with which neither is overjoyed. Thank you for listening to this podcast on mediation. I am Peter Taylor, the managing partner of Paris Smith. I am an accredited mediator. If you would like to learn more about mediation, then please do visit our pages on our website.